James. A little background. There were over 100 applications for the various license in this process. To date, there are 60 administrative appeals by the various parties. I've been doing this work over 30 years. This is a case of first impressions in many ways, not only with the 2 lawsuits that have been filed in the Franklin County Common Pleas Court, but also the 60 administrative appeals. The 119 process is not new. What is new is the process by which the Department of Commerce is going to move these hearings forward. Just for a little background, the way it works, you file your appeal. We made requests for discovery. We got a letter back from the state saying you're not entitled to discovery. If you read the statute, it does not say discovery is not allowed. What it says, it's up to the department to determine what type of due process each individual applicant is going to have. They have made a determination that simply there will be no due process, there will be no discovery. So what we've done or had to do is try to do it through the public records request, and there's no way of knowing what you're getting or not getting. And on a side note, those who might be familiar with the administrative process, if there's one thing that is a lawyer's nightmare, it's the administrative process. You could have God on your side, and once that determination is made by the hearing examiner, he or she will make a recommendation. It will go to the director. The director can modify, accept, or reject that recommendation in its total. Then from there, if the process goes on, you appeal to the Common Pleas Court. So you're right back to the court where we are today. The 2 lawsuits involve 6 parties. There's another case pending in the Common Pleas Court. We believe that this is the right jurisdiction to adjudicate these matters. We will be starting out with aggressive discovery. We feel that's the only way to get to a fair and impartial result. The one thing that we do know, we have Auditor Yost's comments, we have the Director of Commerce comments. There was something that was problematic in the scoring, in the implementation of this program, and I think all of us, irrespective of our position, what we expect of government is to be fair, to be impartial, and to be inconsistent. And that, ladies and gentlemen, is what we have not gotten, and we will pursue this. And I think from the public standpoint, I think the public will want this to go forward. Mary?
Let me echo some of Larry's comments, because as journalists, you appreciate the importance of access to public records. You understand the importance of knowing what the government agencies have done. And you'll find it interesting that we served a public records request on the Department of Commerce in middle of December, maybe earlier than that. And yesterday, a couple days after we filed this lawsuit, we received an email from the Department of Commerce that the records we'd asked, at least some of them, would be made available today at noon. That's a pretty remarkable story when you consider that we've been making an effort for over 2 months now to get to the bottom of what has occurred. And as Larry's outlined for you, first there was the game of playing block all discovery in the administrative context. But second, the games that have been played with public records are quite amazing. The public record statute says the records belong to the public. They're yours. You're entitled to look at them. In fact, if you make a request to inspect records, they're supposed to be made during regular business hours. That didn't happen. If you make a request for a copy, they're supposed to be made available to you within a reasonable period of time. That didn't happen. So one of the aspects of the case we have filed seeks relief under the Public Records Act, much like the statute you as journalists would seek to invoke to gain access to your own records. Why the state of Ohio can't respond to a public records request in less than 2 months is something we don't have an explanation for, but will be the subject of discovery. The other thing that's very important to follow up on Larry's comments is that there is a dual track process here. And because each of those processes seek different relief. Through the Chapter 119 process, these administrative appeals, we're simply seeking a rescoring, just like the other 60 applicants. We've pointed out the problems with the applications, how they scored them, how that has to be reset. The lawsuit seeks a completely different type of relief. It's not subject to a Chapter 119 appeal. What we're seeking here is a rescoring of all tests. We're not asking the common pleas court judge to change our score. We're simply saying the process in its entirety is flawed. You consider that we always start with the proposition that you hope and expect that state agencies will do the right thing. You hope and expect that if you bring information to a state agency's attention about irregularities, that they'll find a way of addressing it. Those are all reasonable expectations of citizens.